Good afternoon, Steve Brooks here. Welcome to Friday's Inside Look by Brooks. Today's topic is, what kind of law do we practice? This is a question I get asked often when I'm out in the community, and I'm even amongst friends. So I kind of want to give you the 30,000 foot view, and then I will get more granular and talk about the real specific type of law we practice. But in law, there are two specific types of law. There's civil law and criminal law. So we don't do any criminal law. We just practice in the civil arena. And the civil arena covers lots of areas. It can be anywhere from trust and estates to family law to business disputes to personal injury, mortgage foreclosures, anything that has to do with people and property that's not criminal. So, there's a lot of attorneys out there who practice in what I call general practice. I honestly don't know how they do that. We have chosen to specialize in what I call injury law, which is a subset of civil law. And injury law means exactly what it says. If you are injured in a car accident, a motorcycle accident, a truck accident, an ATV accident, an elevator accident, a pedestrian accident, a bicycle accident, any kind of event where someone else is negligent and you're injured would fall under that umbrella. So my philosophy, we have 8 attorneys here at the Brooks Law Group, is if we are focusing and concentrating our efforts on a very limited subset of the law, then we should be able to hone our skills and do that really well, which is what we do, and we continue to try to improve, so we always do it well. So the other thing that confuses people is within civil law, you can represent the plaintiff or the defendant. So again, we've chosen a microcosm. We're already a subset of civil law by just focusing on injuries. And also, we have decided just to represent plaintiffs. We never represent the defendants. I've seen attorneys that try to balance that act and represent plaintiffs on one hand and insurance companies on the other hand. I don't know how they do it. They never seem to, their practices never seem to, it's not something that I would want my practice to be involved in. Because if you're representing insurance companies, first of all, you're drinking their Kool-Aid. And second of all, if you're soliciting insurance companies and you want more insurance companies, companies as clients, so you can represent their interest in a lawsuit where they are the defendant or they're insured as a defendant, then you may have crisscross loyalties if you're representing a plaintiff against an insurance company whose business that you're seeking in the future. It may compromise your advocacy for that plaintiff, and we don't want any potential compromises of our representation of the consumer. So we represent consumers who've been injured. We only represent you, the plaintiff. We only represent parties in injury situations. We do have a separate division, Social Security division. We have one attorney who full-time does nothing but represent Social Security disability clients. Now, some of those clients come to us as a personal injury client to begin with, and because ultimately they're disabled by their injuries, we continue to represent them in the Social Security disability arena. But again, that attorney who works for us in the Social Security disability division does that. 100% of his caseload is disability cases, so he can perfect and hone his craft really well, and he's an excellent attorney. So the other question I get asked is, some people think, because I'll talk about some of our bigger cases, they think that we only handle huge million and multi-million dollar cases. And I'm like, no case is too big, no case is too small. We handle huge multi-million dollar cases, and we handle small soft tissue cases. So it runs the gamut. Another area we practice is if you're injured on somebody's property. We call that premises liability. You may hear a lot of law firms refer to it as slip and fall. There seems to be a misnomer about the liability in a slip and fall or a premises liability case. Typically, a lot of times we have clients come in here and they may have fallen at a local Walmart, and they come in and they've got a serious injury, maybe a knee or hip injury. And they think that because they fell on Walmart's premises, that Walmart is automatically liable. And that's not the way it works. With any injury case, you've got to prove that the other party was negligent, that somehow their actions were deficient and those actions caused you to be injured. So obviously in a car case where someone runs a stop sign, that's obvious. If you're a pedestrian walking down the sidewalk and a guy's texting on his phone and swerves and hits you, again, that's an obvious negligent action by the responsible party. But if you go to Walmart and you're not paying attention and you slip and there's nothing on the ground to cause you to slip, and there's nothing in the store that we could say Walmart did wrong to cause you to fall, then unfortunately that is just an accident. You had an accident and you can't blame Walmart for that. The only time you can blame a corporate defendant or even an individual defendant is if somehow they are responsible for the injury. And I'll give you some examples. Stores need to take precautions for spills, liquid spills on their aisles in their stores. So if they don't have a program in place to monitor that and clean up those spills so you don't step in it and fall, and you go into a local store and you step in a puddle of water, then potentially that store may be liable. So we kind of got to get granular and ask, was the puddle cold or wet? If it was cold and clear, that represents that it was probably a new spill, maybe a minute, 2 minutes before you stepped in it. And it's not reasonable to assume that the store caused that spill. Now, if the water is dirty and the water is warmer, and there's evidence that people have tracked through it, and there's pictures of footprints with dirty footprints walking away from that puddle, then we may be able to argue that puddle had been there a while, and because it had been there a while, the store should have known it was there and should have cleaned it up to prevent you from falling in it. So there's premises liability cases are very nuanced. But getting back to the big topic, we handle big cases, we handle small cases, we handle everything in between, but we only do it from the plaintiff's perspective, never represent the defendant, and we only handle the subset of civil law known as injury or personal injury law. So I hope that clears up a lot of confusion for the questions that I'm frequently asked. Thank you for joining me today. We will be here next Friday with a new topic, and hope everybody has a wonderful weekend. Look forward to seeing you next Friday. Thank you.